to the San Diego chapter of the CCIM Institute's Lunch and Learn series. We're here to promote learning excellence, competency, and collaboration. I'm Doug Tabor, VP of CCIM San Diego. You may know me more as a rental housing realtor with KW Commercial here in La Mesa. My wonderful co-host this morning and fellow board member is Ms. Paris Moe. Paris is a sustainability coordinator at Verdani Partners and recent graduate of the USD MBA and Masters of Real Estate program. How are you this morning, Paris?
I'm good, Doug. Happy to be here with you.
And we are thankful for your participation. We're going to go to the next slide and talk about housekeeping this morning. So, you know, all attendees are in listen-only mode. You are welcome to chat with each other using the chat box. However, if you're going to ask questions, we ask you please use the Q&A box to submit all of your questions. So if you look down below, you have a chat box. You also have a Q&A box. Please use the Q&A box to submit your questions. This webinar is being recorded, and we will be sharing a copy of the webinar, a replay link, at the end of the event. And now for our agenda today. We will be kicking off with our speaker. At around 12:30 or halfway through, we will open up for Q&A. We have received a number of questions submitted prior to the event, but we also love it when participants ask live questions. The speakers do too. It makes all of these events so much more interesting. So be ready to ask those questions. You don't have to wait till 12:30 to ask the questions. Just start putting your questions in the Q&A box, and we will go through all the questions when we get to that point. Typically, we conclude at 1 p.m., but if we have extra questions today that haven't been answered yet, our speaker, Richard, did mention that we might be able to go a little bit over. So if you have questions, we are going to make a point to answer all of them. So a little bit about CCIM. In case you're wondering, CCIM stands for Certified Commercial Investment Member. Our membership is made up of commercial real estate professionals from across the globe. The CCIM lapel pin denotes that the wearer has completed advanced coursework in real estate economics and investing and demonstrated proven industry experience. As a local chapter, we focus on education and networking events, much like this one, that promote excellence, competency, and collaboration. You can find out more about becoming a CCIM designee and our upcoming events by visiting ccimsandiego.com. You could follow our new LinkedIn page and take a moment and subscribe to our YouTube channel. Now, if I may, I would like to take a moment to thank our generous sponsors for 2020. Our platinum sponsors include Chase Commercial Lending, HechtSolberg, Marcus & Milchap, Marsh McLennan, Procopio, and Savills Global Real Estate Experts. Our gold sponsors are CoStar, Exeter 1031 Exchange Services, Lankford & Associates, Pacific Medical Buildings, Slat Capital, and SCS Engineers. We thank you for your continued support, especially in this roller coaster of a ride we call 2020. And now, I want to take a moment before we introduce our speaker and open up a poll. We've told you a little bit about who we are. What we like to do is find out who our attendees in our audience is. So if you could just take a moment and engage this poll, let us know who you are in the audience. These polls are always a little bit of fun, and they ensure that you guys are actually paying attention and not just browsing the internet, which is always so tempting to do. All right, we have a number of folks that are responding to the poll. So what role do you play in the San Diego commercial real estate industry? We have 45% owner investor, no developers today, they must be on the job site. 8% lenders, 21% brokers, 8% property managers. Richard, looks like you're the only attorney with us today, and 18% are other. So we have a good mix of folks. Thank you for taking that poll. We will have another poll later on in the event. Now, I would like to introduce our speaker today covering this contentious Proposition 15. Our speaker is Richard Schulman with HechtSolberg. Richard specializes in a variety of land use, municipal, and environmental matters pertaining to commercial real estate. His practice includes a significant amount of appellate work, and he has served as an adjunct professor of law and business at the University of San Diego. I'm delighted to introduce our speaker of the day, Richard Schulman. How are you today, Richard?
I'm good, Doug. Thank you for the introduction. Speaking of attorneys on the poll, I'm wearing my Sharks with Briefcases tie. Could we have the first slide, please? Thank you. Next slide. The Proposition 15, as Doug said, is going to be on the ballot in November, and it is likely to be contentious, judging by similar efforts that have been made in the past. First, I want to make sure we're all on the same page on background, introductory, foundational matters. We're talking about the semi-annual property tax bill that you get from the county. We're not talking about what the government takes in other contexts, such as sales tax. As we'll see later on, there's some overlap in the distribution of how the funds will go from this proposition if it's passed. Property taxes are taken locally, but defined by the state. The money goes to local governments. Next slide, please. Most of what you pay on your property tax bill is what's called an ad valorem tax. That means it's taken against the value of the property. It covers all kinds of property interests, including long leaseholds. There are a number of exemptions, such as charities. Most states, including California before the granddaddy Prop 13 in 1978, had each taxing agency set its own tax rate. This is a CCIM group. I assume you all know tax rate times base equals total. So the total tax was the sum of the agencies. Sure, at this point you already know it's payable in halves. Every state will foreclose if you don't pay. In California, the legal fiction is the property taxes become a lien on the lien date. Next slide, please. There are many topics in California law that are subject to a lot of changing, developing, let's call them, court decisions. One of the elements of Proposition 13 in 1978 was any special tax, which unfortunately the proposition didn't define, requires a 2/3 vote of the district upon which it was going to be imposed. That led to 2 or 3 follow-up initiatives and about 20 or 30 court decisions asking the somewhat Bill Clinton-esque question, what do you really mean special tax? Out of those decisions came a rule from the state Supreme Court that a tax is money the government forces you to pay and you don't get anything for it. I don't mean to sound cynical or sarcastic, that's pretty much what those opinions say. So what's on your property tax bill, as I said a moment ago, is principally the ad valorem tax. There are some other taxes on it, such as in many areas, the so-called Mello-Roos tax. But there are also special assessments that under these decisions are defined by the benefit to the property. Your tax bill may, for example, have a 1911 Act assessment or a 1915 Act bond on it. I live in Tierra Santa, so I pay a little bit twice a year to a lighting and landscaping district. What is not on the property tax bill usually is things like development impact fees. I noticed there were no developers on the list. Occasionally, there are regulatory fees. Occasionally, there are processing fees. Cost of ordering you to do things, cost of processing your application, but those are rare. More frequently, there will be a user fee, such as water. What this matters for Proposition 15 is Proposition 15 only affects the ad valorem portion of that tax bill. It's the biggest single part of your tax bill, but it is only one part. Next slide, please. This speaks for itself. This came up in the context of the then governor's proposed fee for a water resources fund. And it pretty much encapsulates the court decisions as well. Next slide, please. So what do you pay? What does the property tax consist of? As I said before, most of it is the assessed value. According to Proposition 13, the maximum tax is 1% of the assessed value plus some pre-approved matters, such as bonds, plus what is approved under the 2/3 or majority, or however the courts interpret the voter requirement, plus the non-assessed value charges. Under Proposition 13 and its follow-ups, 65, 73, 78, increases in the tax rate or other charges usually require some kind of voter approval. Under Proposition 13, the increases in the assessed value are more or less automatic. They had been going up with market value, but one of the main purposes of Proposition 13 at the time was to keep older people from being thrown out of their homes by large tax increases. Back in the 70s, a lot of it was simply inflation. So Proposition 13 limited annual increases in assessed value to 2% per year until sold, what's called a change of ownership. There are a few exemptions for that the legislature has approved, that the voters have approved, for example, trust deeds, spouses, interspousal grants. The technicalities, such as trustees, have generated about, I took this block of revenue and taxation code sections, put it into a Word doc, and it told me there were 22,000 words just defining a change of ownership. Next slide, please. So what is Proposition 15? The tax roll is just the list of the properties being taxed. Proposition 15 would create a so-called split roll so that some properties pay more or pay a higher rate compared to assessed value than other properties. You can do that by changing the tax rate for them. You can do that by changing the tax base, the market value. You can do that by changing exemptions or some combination. The split roll has been on the ballot several times in the past since Prop 13 was approved, and it has failed each time. Each time the commercial, industrial, and under some of the proposals, apartment owners have contributed heavily to campaigns to defeat the propositions. The reason I'm here today is the only poll that I've seen was very early and probably not significant, but it is probably going to pass this time. I'm not here to argue for or against it. I'm just here to tell you how it will work. Next slide, please. What Proposition 15 will generally do is, instead of limiting increases in assessed value to 2% per year, it will require the more or less immediate reassessment of all commercial and industrial properties to appropriate market value. So it increases the taxes, it creates the split roll by increasing assessed value. It will produce between about $6 and $11 billion per year once it's up and running, according to the Legislative Council's estimate, let's call it. The Legislative Council is the legislature's legal advisors, and they're the ones who put the more or less neutral summaries of the effect of each initiative into the material that you get before each election. Most of the money would go to local governments and schools. Some of the money will be taken off the top to local governments for administrative costs of dealing with this increase. For example, the county is going to probably hire a lot of appraisers. Some of the money goes to reimburse the state because of an income tax effect. If you are operating a business and you pay more in property taxes, your income has dropped, and therefore the income taxes, franchise fees, whatever, will drop slightly. So people at the state are going to have to figure out that number, and some will go to reimburse the state. Still, quite a few billions of dollars will go to local governments and schools. I've seen a number of estimates in the past of what an initiative would provide in the way of funding. And I don't recall seeing an estimate where the top was roughly double the bottom. There's a lot of uncertainty to this one. Increases for residential properties would still be subject to Proposition 13's 2% per year limit. And the proposition defines residential to include multifamily, both owner-occupied and rental. So this should not affect apartments in themselves. Get back to that in a bit later. We're talking about potentially a lot of money. And I've got a couple of sample numbers here. This is a CCIM group. You all know how exponents and continuous interest work. But just taking these numbers, you can see there's a roughly 30% difference after 5 years. Now, a 5% increase is probably an underestimate, except for this year. We all know there are years it goes, property values might rise 20%, might drop 2%, might rise 6%, but still, this is going to be a lot of money. This will come up in two different contexts. There's a sudden huge increase when the property is reassessed, if you have owned the property for a long time. Then going forward, you'll be paying more each year. One of the pre-questions that we received was, wouldn't this be good to smooth out the sudden increases from a purchase? That's correct, but when you buy property, you're running your own pro formas from the beginning usually. Next slide, please. So, details. Commercial, industrial, office. The proposition doesn't really define this. It uses the somewhat circular definition that it is property that is, quote, used as commercial or industrial property, unquote. And includes vacant land as long as it's not residential. If it is multifamily, the rule is that the exclusion from the increase, so don't worry about it, for multifamily includes the land on which the structures are placed. So there's not going to be a distinction like when you see normally on your property tax bill, there's the land value and then there's the structure improvement value. If you're talking about multifamily, that in itself will not trigger an increase. However, there's an asterisk here for if you have, for example, a large project and you have a lot of common areas, swimming pools, recreational facilities, fitness gyms, the legislature will decide how to deal with that issue later. The proposition does not itself define what those numbers will be. Limited commercial uses of a residential property do not trigger the increase. The specifics of that will also be defined by legislation. There were originally two different propositions kicking around, or to be more precise, for which signatures were being submitted to the state. One of them, this was an issue, but Proposition 15 was specifically written so that people don't have to suddenly face an increase for the home because they're using their home as an office, particularly important these days. There's also an exclusion from the increase for agricultural property, farms, which are defined basically as you're actually doing something, producing farmland. There's also an exclusion for open space, which is reasonably clearly defined. The conceptual definition is you can't do anything with it. It's not how it's worded, but realistically. If you have a mixed use property, so for example, the ground floor is commercial and then floors 2, 3, and 4 are residential, it will be done by portion. So the residential portion will have a tax increase. The commercial portion will not be affected by this property. There is another exemption for personal property of a small business. There is another exemption for the first $500,000 of personal property of not small businesses. Get to small business in a moment. Next slide, please. When? Starts in fiscal 22-23. The state is on a fiscal year that begins July 1 and ends June 30. We are currently in the fiscal year 2021, so this is 2 years away. It is to be phased in to recognize administrative efficiency and ability to get it done. The proposition does not say who gets reassessed first. That seems to be luck of the draw. The legislature will establish a task force to figure out these details. The task force will not be dominated by people who actually will be paying the tax. A good question is, when am I going to get reassessed? It doesn't say. There's an implication that you will be reassessed within 3 years, which would be fiscal 25-26. But that implication only arises from the fact that everybody is to be reassessed every 3 years once they've been reassessed the first time. I couldn't find anything in the initiative on when, and to double check, I looked at the Legislative Council's summary that's in the ballot materials, and they can't figure it out either. There's an exception on the when. There is a later phase-in for properties that are largely occupied by small businesses. The property owner has to certify this under penalty of perjury, which gets to one of the lease issues I'll deal with later. The definition of a small business has three elements, all of which have to be satisfied to get this exemption. One is it's small. There are fewer than 50 full-time equivalent employees. One is it is independent, which means it is defined in the proposition that the business in question is not run from somewhere else. The last one, remember you have to satisfy all three, is that the business owns real property elsewhere in California. I cannot for the life of me understand this last one. Remember, the business in question is not necessarily the owner of the business. So for example, if you are just operating yourself as Richard Schulman, an attorney, in an office, you yourself are the owner, and so you yourself would be subject to this requirement. But if you are a typical business and you're the XYZ corporation or limited liability company, and your business has fewer than 50 employees and is not run from Chicago, the business still has to own real property elsewhere in California to qualify for this exemption. Next slide, please. Who? The proposition is explicitly aimed at big commercial businesses. There is an exemption for entities, owners, that do not have a, quote, direct or beneficial, unquote, ownership in other property in the state worth more than $3 million. How do you prove that? Good luck. Going to be a lot of documentation, and you're going to have to show how little your other properties are worth. What does it mean, direct or beneficial interest? The proposition itself does not define that. There's a lot of law in the context of trusts, estates, and so on that does. My suspicion, my expectation based on how courts deal with taxes in this state is this part will be defined broadly, but it will be 5 years before we all find out. I mentioned previously that the personal property of a small business is exempt. For not small businesses, the first $500,000 is exempt. The property tax is not just real property. It does include, depending on the nature of what's being taxed and what is there, some, for example, furnitures, fixtures, equipment. So you might want to consider, for example, if you have a large shopping center, you've got a Target in one area, you've got 5 dry cleaners, Chinese restaurants, whatever, in the rest of it, you might want to consider dividing it to see if you can take advantage of the small business rules. But again, those small businesses have to own other property in California. Next slide, please. How is this going to work and how can you challenge it? The county assessor will do the reassessments. The legislature, as I said, is supposed to establish a task force to help identify administrative issues, help resolve administrative issues, but the assessments will be done under the usual rules. CCIM, you already know the 3 usual appraisal matters. Interesting question, how much can you say that the value of the property has been reduced by the increased tax? But I'll let the appraisers deal with that. The burden of proof had not previously been very clear. It used to be just preponderance of evidence. It has now shifted in this proposition so that the property owner has a burden of proof that the assessment is too high. It's tough to overcome because if you then end up in court, the standard is the legal phrase abuse of discretion, which includes the legal phrase substantial evidence, which means that as long as the county had credible evidence on which a reasonable person could rely, you lose. There are also a number of time deadlines. There was a recent appellate court opinion that held that the time deadlines to challenge property taxes had to be construed very strictly, even though the time for the government to respond does not. It's California, you all know that. Next slide, please. The next, I think, 8 slides are typical lease language. And I have these in here just to highlight issues. Some of them are very obvious. The first slide, for example, is just a sample. It says it's a typical triple net lease, tenant pays. The fun parts are in the next bunch of slides. Next slide, please. So suppose, for example, you are in one of these small business occupied commercial properties. The landlord gets the tax bill. How can anybody know to show that you might be able to be exempt because you have a lot of small businesses? Suppose, for example, that you have the now popular, and popular 200 years ago, ground floor commercial, upper floors residential. If the landlord gets the bill and the tenant is paying the taxes, what incentive does the landlord have to make sure that the tenant knows what's going on, and somebody has the incentive to challenge it? Next slide, please. This is a typical reassessment provision that says in essence, and I hate criticizing my brethren for using too many syllables, if the property sells, the tenant still pays the higher taxes. This might or might not become moot. If the property is, for example, owned by somebody who owns less than $3 million of property in the state, this still matters. If the property is owned by a large company, it might not matter. But then again, it will matter for the next couple of years until the property is reassessed. Next slide, please. Share of a larger area. This gets into the common interest areas. This gets into the question that you get for shopping centers. Well, what happens if you've got a Target and 5 local small businesses? You might want to consider a parcel map to divide it. You might not. It depends on whether you think you can prove that these are small businesses. And again, the really tricky part is the small business has to own other property. If you can prove it, you have to allocate it somehow. This is going to turn into an interesting battle of economists and appraisers. Next slide, please. Sometimes the leasehold is separately assessed. Sometimes it is not. And you need to watch out for that issue in light of the changes wrought by Prop 15. Next slide, please. Protests. Again, these are possible typical language, but the reason the slide is here is to highlight the issue. Somebody needs to know to protest. Somebody needs to know to protest timely. Somebody needs to have the evidence on which the protest can be based. And that may require, given the details of Prop 15, having information about all of the businesses on the site. Perhaps you're operating a small, independent, non-subway sandwich shop. You chat with your fellow tenants, and lo and behold, there are 4 others. 3 of them own other property in the area. The 5th doesn't. You add up your square footages, and your square footages are, say, 20,000 square feet. Target typically is around 160 to 180. What do you do? Again, I'm not here to give legal advice. My point is, these are the issues that you will need to address in your leases going forward. Next slide, please. This is basically the same issue. In many commercial leases, the landlord gives an estimate of rent, excuse me, of taxes to be paid to each of the tenants in advance, so that the tenant can smooth out their cash flow and pay 1/12 each month. Good luck with that estimate. First, good luck, because you don't know when you're going to be reassessed. Second, when you get reassessed, all of a sudden you have a whole new number, and it's probably not going to coincide with your lease terms, the beginning and end of the lease periods. Next slide, please. Personal property. If the tenant is a small business, and the individual tenant may be, then it's possible that the tenant would be exempt from having to pay on FFE or FF&E, but you might not. So again, these are standard clauses, and everybody is going to have to take a very close look at these if Prop 15 passes. Next slide, please. So what do you do? Going forward, pretty obvious. You need very clear language. On a side note, I can't resist pointing out, I've been in a number of negotiations with other attorneys, and when I've seen the classic lists like release, hypothecate, lien, with 15 different synonyms, and I ask the other attorney, what are these other ones for? The answer is typically, I don't know, we've always had them. Clear language helps. The managing partner at our firm, Mickey Marr, has a saying he loves to repeat to junior associates, which is, legal writing is the only form of English prose in which your reader is trying to twist what you said. My personal preference is short and clear, but it's up to you. Specific topics to address going forward include what we've been talking about. If you have a small business tenant, personal property. If you have a landlord that owns anything else, what else do they own? Timing for the increases. Who has the protest right and who might have the protest duty? Who has the right and who has the duty to simply give information to the county? Because when the county assessor does the reassessment, they will probably ask for income information. You all know the 3 bases for an appraisal, and income information is crucial in a lot of these situations. Other exemption informations, the dollar triggers for the $500,000 personal property exemption, the dollar trigger for other ownership. You need to make sure that you address information and notices so that if anybody might fit into one of these, they have the clear opportunity to do so. If you are a commercial landlord, one of the last things you want is a letter from your tenant's lawyer saying, you didn't tell us we could protest this and you cost us $3,000 a month. What can you do for existing leases? Not a whole lot. The points that I have here are just sort of general background. I'm sure you're all already aware of most of these. California judges love residential tenants. When residential isn't involved, it's hard to find a pattern. They might favor the smaller tenant at the expense of the bigger landlord, depending on market power and sophistication. I'm involved a lot with big parties on both sides. It's hard to see a pattern, but you can expect some problems. You may also expect requests to amend the lease to address these issues. I strongly suggest that you do so, because especially if you look at your current lease and you think, I think I would interpret this way, but I can see where a reasonable person on the other side might interpret it the opposite. And I think that's my last slide, and we're ready for questions. Quick audience poll. Doug, did you want to do this?
No, go ahead.
Okay.
It's going to be
from what you know of the proposition, how many of you would, at this point, probably vote yes, and how many would probably vote no, or not sure?
all right. A lot of no's in the audience. Well, there you have it. Richard?
Wow. This is pretty similar to what I've seen in the past in election campaigns, because as I said early on, the commercial and industrial property owners who would be stuck with this huge tax increase are going to be very unhappy. I think the previous ones on the ballot also increased apartments, but I'm not sure. So, questions?
All right, Paris. Paris, we can't hear you. Not sure if you're on mute.
Apologies.
There you go. Take it away.
Yeah, still trying to get the hang of it. Yeah, so we've received quite a few live questions already. So we will take those live questions first and then try to address some of the pre-submitted questions at the end. Right. And the first question is, how would Proposition 15 impact private golf country clubs?
I'm sorry, I heard private what?
Private golf country clubs.
I'm still not hearing the last couple words, I'm sorry.
Private golf country clubs.
Country clubs?
Am I coming off?
Okay, sorry, the question is country clubs. That's an interesting question. I don't think it fits into the open space definition. I don't think it fits into the agricultural definition, unless you think you're selling the mowed lawn. It would probably be considered commercial and industrial under other case law, holding that these things are essentially commercial. But that's an interesting question. I don't know. Have to wait to see how that works out.
Thank you. Let's take the next question. This one asks, has the county assessor office provided any comment on the impact, financial and otherwise, should Proposition 15 passes?
The county, not that I know of. The state, as I said, is estimating between $6 and $11 billion per year once it's up and running. San Diego County, you can take a rough guess, is a little under 1/10 of the state. So you can probably figure it's somewhere in the vicinity of $500 million to $6 billion per year. No, that's not right. $500 million to $1 billion per year. But I have not seen a number from the county. I think they're still trying to figure that out.
The next one asks, if the taxes go up, won't the price go down inevitably because people won't be able to afford the increased taxes? What's your opinion on that?
Speaking as a former cut-rate economist, before law school, I worked as an economic analyst. Yeah, exactly how much will be subject to argument. Suppose, for example, that your taxes over the course of, say, 5 years, in the examples, the number that I gave, go up by 1/3. Let's call that, say, $50,000 a year. What's the net present value of $50,000 a year extra in lost income, net lost income? It depends on your discount rate. That can be a lot.
It'll be interesting to see how it plays out in the market. Right. So this next question asks, the teachers union lobbied in 2011 to abolish redevelopment agencies to benefit schools. Has there been any analysis on whether the funding actually improved the state schools? And affordable housing was significantly impacted as a result of that dissolution. And has there been any linkage to the union move and the imbalance in the housing supply?
That's a political question. I have seen numbers from people who are in favor of this saying it's a great thing. I've seen numbers from people who dislike it saying it's a horrible thing. Has there been an increase in affordable housing since the abolition of redevelopment agencies? Of course not. The California Building Industry Association puts out numbers for the state. The Building Industry Association of San Diego County puts out numbers for the county. Absolutely not.
Thank you for your insight. All right, the next one. It asks, could small businesses, as defined in Proposition 15, put their houses in their business name, and could that count?
I think so. That's pretty clever. As a lawyer, I have to qualify this, of course, by saying, well, I can't give legal advice today. I'd have to read, 5,000 pieces of paper. But certainly on the surface, if the business that is the tenant owns other real property, then you may qualify for the small business benefits of the proposition.
Thank you. And could you reiterate if the Proposition 15 impacts single family or apartment rental?
No, it does not. There are, I think, 3 reasons for that, and they're all political. Looking back on the history of these things, one of what's going on is just to raise some more money. And one of the reasons that I expect this to be approved this year is because all the governments are screaming that they're short on funds. Another is to adjust what a lot of people thought was the unfairness of Proposition 13, limiting commercial increases along with residential. As I said, I was 23, which tells you how old I am, in 1978 and voted for Proposition 13, but I never quite understood the 2% per year limit. The third reason can best be summarized by the political aphorism, don't tax you, don't tax me, tax that guy behind the tree. Somebody else is supposed to pay for this.
Got it. All right. So this next one asks, what is the date on which the $3 million exemption will be considered?
The state?
The date.
It says in California. It says in California.
The date. I'm sorry. I think the question is referring to the date as in time. Is that
date.
specified?
Date. Yeah. It's as of when the reassessment is to be considered.
Okay. And if there is any estimates about the cost of implementing Proposition 15 and the maintenance and enforcement?
I have not seen an official estimate. Neither the Legislative Council nor the people who put the proposition together provided that. I think there would be a lot of guesswork. Just on my experience with government, I would probably figure 8 figures. But if you add all of the, for example, hiring of new appraisers that the assessors are going to have to do, could be 9 figures. The assessment, as you know, for a single family house is very simple. We've all seen, if you purchased a single family house or condominium, you've seen that the assessment is typically a very easy form. Reassessing these properties is going to be very difficult and somewhat of an argumentative process.
At least someone in the industry is a winner, the appraisers.
And the lawyers. The lawyers always win.
The next question addressed, why would small businesses have to own property to qualify for the exclusion from reassessment in your opinion? So does that mean if a small business is not rich enough to own property in its business name, it doesn't deserve a tax break?
I'll preface my answer by saying I didn't write this. I've looked at it. I cannot understand. I've looked at it many times. I've compared my reading to the Legislative Council. It says what it says. Why did they do it? I have no idea. I sort of vaguely recall seeing in the political discussions months ago when the proposition was being circulated for signatures, something to the effect of, we'll get them somewhere else. But I don't really think that's a viable reason because of the dollar limit and because of the possible distinction between the business and the owner of the business. You might think of yourself as running the pizza parlor and you have 6 employees, but if your business is called Tierra Santa Pizza LLC, that's what's got to own it. So I have no idea. It seems utterly incongruous to me. It seems to conflict with the idea that it is truly small, because typically small businesses are small.
That brings up a good point, Richard. You might have covered it. Who did write this bill?
The version of the initiative that I've provided to CCIM, which I believe will be made available to everybody, includes the communications from the sponsors. The sponsors appear to be individuals. My understanding from what I've read in news articles is that it's the usual suspects. The people who would get the money directly or indirectly, let me put it that way.
All right, our last live question asks, is this Proposition 15 impact personal properties?
Yes, subject to the 2 exemptions. Personal property for a small business, as defined, is simply exempt from the increase. The first $500,000 for larger businesses is exempt from the increase. Note that I am emphasizing the phrase "from the increase." However they were taxed before will continue to be how they are taxed.
Understood. All right, so we've gone through all of our live questions at this moment. We will address some of the previously received questions from attendees at registration. So the first one asks, how long is it projected to take for non-residential appraisals to be completed to establish their new tax basis? And under Proposition 15, how often will properties be reappraised?
The second question is very easy to answer. Once it's up and running, every 3 years. That comes with the asterisk. That's what the proposition says. And we all know how government can miss its own deadlines. The answer to the first question is a lot tougher. The proposition doesn't say, the Legislative Council summary doesn't say. There's an implication, I think it's more of a hope, that it will be done within 3 years because the reassessments, once done, are supposed to be reviewed every 3 years. So your property tax should only go up by 2% per year for 2 years after the reassessment, and then you'll get nailed again, to be blunt. But how long does it take the first time around? It doesn't really say, nor does it say who, whether it's your parcel number is divisible by 3 is the first year, and if you have a remainder of 1 the second year, and if you have a remainder of 2 the third year. I have no idea. I suspect it's going to be luck.
Where would you suggest our audience to look to and expect in search of this answer in the near future if this bill was to pass?
I'm here because I suspect it well. I recognize the massive outpouring of opposition from this group, but this group is not a randomly selected sample of the state's voters. We all know how powerful the various public employees unions have gotten in this state. We all know what the voting has been in the state on other matters. And the don't tax you, don't tax me aspect of this is particularly appealing. To defeat it, the commercial and industrial property owners are going to have to put on a massive outpouring of opposition campaigning. I think the exclusion for apartments from this increase was probably as much strategic as it was economic or political. By economic or political, I mean they didn't want to hit people where they lived. But by strategic, I think it was a deliberate choice to reduce the number of people on the other side. because if you also had the apartment owners opposing this proposition, there would be a lot more funding, there would be a lot more push. I can see every property manager out there with signs on their lawns. So again, I think it's too early to, I saw early poll indicating some support. I don't think any poll is meaningful until probably mid-October. This is a very unusual year. George Bush the first had approval ratings in the low 90% during the Gulf War, and he got, what, 35, 38% of the vote in 92. And these times today are very, let's call them dynamic politically. So I don't know, but just generally given the tenor of things, I think it's going to be a hard push to oppose it.
And if it passed, would any action be held up by litigation, in your opinion?
Held up by what?
Litigation.
Oh, well, as a litigator, I'd love to say yes, give me a call, but realistically, no. I think I saw, if I'm reading the little Zoom boxes correctly, there was a question somebody wanted to ask about whether this would require a 2/3 vote. I'm pretty sure the answer to that is going to be no in court. Prop 13 did say special taxes require a 2/3 vote. And as I said, some of the follow-up initiatives, shall we say, clarifying judicial opinions, defined what that meant and defined what a special tax was. I see two problems. One is the last 20 or so years, judges have been very, let's say they scrimp on identifying something as a special tax. They'll call it a development impact fee, a user fee, a regulatory fee, a processing fee, a general tax. This one, I think there's an obvious out in that it's not actually a tax. It's a change in the tax base for some properties. The other problem that I see is there's a recent line of court decisions, a state Supreme Court case and an appellate case, that basically say that the 2/3 limit that applies to local agencies, and this arguably applies to local agencies, arguably doesn't, but even the 2/3 limit that does apply to local agencies doesn't apply to initiatives. On a personal note, I've had 6 or 8, 10, maybe a dozen opinion pieces on legal matters published in the LA Daily Journal, which is the principal legal newspaper in LA and the state, and the San Diego Daily Transcript, which I don't know if I'm supposed to say rest in peace. One of them, when the voters in San Francisco approved a homeless tax on certain businesses a couple of years ago, one of my columns said, this is clearly a special tax, should fail because it got less than 2/3 of a vote, but judges will undoubtedly find a way to approve it. That was one of the ones that was upheld in one of these recent court cases. And the theory was it's an initiative and the 2/3 requirement doesn't apply to an initiative. I'm not sure if that means that other aspects of the state constitution don't apply to initiatives. You can just hypothesize some great questions to put on the ballot, but that was the decision.
That's very interesting to know. On the brighter side, do you think the passing of Proposition 15, given that it would be a good thing, given that it will eliminate the shocks to commercial tenants when a scale occurs and taxes increase?
I think I touched on that before briefly. A longer answer would be yes, it would eliminate the shock from a reassessment, but you have to compare that to paying more all along the time. I will not weigh that for your particular situation. I'm not going to give you my own political conclusion. I'm just saying there's a balance.
Thank you. And lastly, could you reiterate for us how Proposition 15 will affect mixed-use commercial properties?
The way the proposition reads, the assessor is supposed to separate, at least analytically, if not by a parcel map, the commercial portion from the residential portion. So my example was the ground floor commercial, and then floors 2 through 4 are residential. I've had clients with that kind of situation. Typically, you do not have those in separate ownerships. You do not have those in separate parcels that have been legally subdivided under the Subdivision Map Act. Perhaps you do, but if you do, then the question doesn't come up because you've already got one commercial property and one residential property. So assuming this is all one parcel, the analysis, the appraisal is supposed to reflect that and take the portion that is commercial and raise the assessed value subject to the various exemptions, covenants, conditions, exclusions, restrictions, qualifications, and asterisks, and not raise the apartment portion by more than 2% per year. I suspect what's going to happen is that your property tax bill in the future will distinguish not only land value from improvement value, but there may also be in the future a line saying commercial value versus residential value, because I don't see how they can show their math, show their work without doing that.
Thank you for that answer, Richard. And thank you for answering all the other questions. We appreciate all the attendees for participating as well. I believe that's a wrap for the Q&A session.
All right, thank you very much, Paris. Richard, do you have any final words for the attendees?
Thank you, but no.
Okay, well.
I could offer my political thoughts, but I don't want to.
Thank you. Well, on behalf of CCIM San Diego, a big thank you to our speaker this morning, Mr. Richard Schulman. Find out more about Richard and his firm, HechtSolberg, at HechtSolberg.com. That's HechtSolberg.com. And also, we will be sending out Richard's contact information to all those who registered with a link for a replay of this video. A lot of detailed technical information here. I think I'm going to go back and watch it again myself because these are big, important issues that we're going to be facing in the month of November. To all our attendees, you don't want to miss our next event on October 2nd. We are going to be having a City of San Diego mayoral candidates. We don't want to call it a debate, but we're all going to be talking, and we're really looking forward to that. That's going to be a joint program with some of the other associations in town. And again, if you want to register for that event or learn more about becoming a CCIM designee or more about what our local chapter is doing, please visit ccimsandiego.com or go to our LinkedIn page or YouTube page. We look forward to seeing you then. For CCIM San Diego, I'm Doug Tabor. Be well and have a successful week, everyone. Take care.
Yeah.
Take care. Goodbye.